Hi, everyone. Welcome to our webinar today on commercial lease essentials, what every landlord should know. My name is Shayne Savage. I am LegalVision's practice leader in the leasing team, and thank you so much for joining me today. Before we begin, a couple of quick housekeeping items. First, you'll receive the recording and slides to your email after the webinar finishes. Secondly, please submit your questions in the Q&A box and I'll answer them at the end of the webinar. Please also complete the feedback survey after the webinar. And lastly, please be sure to stay until the end of the webinar for your chance to win our Apple AirPods monthly draw. Good luck to everyone. By viewing this webinar, you qualify to receive a complimentary consultation with us at LegalVision to discuss how we can help your business. To claim this offer, please leave your contact details in the survey that will appear when the webinar ends, or please feel free to contact us via our website. So today, what we'll be discussing are the key differences between retail and commercial leases and their key lease clauses such as bonds, bank guarantees, maintenance and repair obligations, as well as make good obligations and incentives that you might be looking to offer to tenants. So let's get started in discussing the key differences between retail and commercial leases. For commercial buildings, there are two types of leases in Australia. First being the retail leases, and these are leases that are covered by each state's retail legislation, and that's their respective acts that I'll refer to today. Having a retail tenant may not be as favorable to you as a landlord because retail legislations do give additional protections to tenants. And if a lease is not retail, then it ends up being a commercial lease. And commercial leases may be more favorable to you as a landlord because you can recover more additional costs payable by tenants, such as full outgoings costs, capital costs, and that's always subject to the parties negotiating those requirements into the lease. Generally speaking, retail leases apply where the premises are used wholly or predominantly for a retail purpose, such as cafes, restaurants, fruit shops, clothing stores, or where a premises is located within a retail shopping center. So even if the permitted use of a lease is, say, an office, which is generally not a retail lease, because the premises is located within the shopping center, then it could be still captured as a retail lease under the state's acts. Given that each state has its own retail legislation, there are differences in how exactly a retail shop is defined. For example, some states, such as New South Wales, classify small bars and gyms as retail premises, whereas these are generally considered to remain as commercial in Queensland. So it is really important that we understand which state that you're operating and your building is from, so that we can make sure that those differences between each state are correctly included into your lease documentation. Also, moving to discuss the state of Victoria. Victoria does have a more inclusive definition of what is classified as a retail shop in its legislation, as it does go further to also include providing services to the ultimate consumer. So that's in addition to, the retail shops of being a cafe, for instance. So that means that with providing services to ultimate consumers, that means that medical practices, car repair service stations, accounting services, even warehouses can be classified as retail shops in Victoria instead of remaining as commercial. So that's something really important to think of if you are located in Victoria. The spirit of the retail legislation is mainly to protect small to medium business owners who are tenants rather than large tenant corporations. And we can see this being included into the acts because each act does have its own type of exclusions. So even if a premises is used for a retail purpose, as mentioned above, that lease could end up being excluded from the act because, for instance, if a tenant or its holding company is a listed company, they would be excluded in some states. And this is really going back to the spirit of the legislation in that a listed company would most likely have, larger, be a larger, it is a larger corporation and would have larger pockets to pay for lease costs, and there's not necessarily needing the protections of the act. And that also goes for some states have where the lease term is, say, over 25 years, given that this is a large monetary commitment being committed by the tenant. It's generally not a small business owner that would be making that commitment. So it's an exclusion there as well. There are other exclusions, so it is really important to understand the lease terms that you have and also the tenant that is going into your premises to see if there are any exclusions. Also, to retail leases, there's generally prescribed disclosure obligations. So from each state legislation, there generally includes a specific form for the landlord's disclosure. And a landlord's disclosure statement is generally completed and signed by a landlord or its agent and issued to the tenant prior to the lease being negotiated and finalized. You can think of this disclosure statement as being a summarized version of the lease terms containing all of the key information and costs that are payable by the tenant under the lease so that the tenant is fully aware of what it is committing to. The retail legislations also prescribe some other items as well that we'll discuss. And going back to how the spirit of the act is to protect small business owners, this is really where it's essential to understand whether there are items that should be included in a lease from a landlord perspective as whether it must be included or must not be included, because there are items that need to be prohibited and not included in lease documents. Whereas for commercial lease, there are not these additional protections and the parties are able to negotiate those positions themselves and there's not that additional protection. So one of the first items that are prescribed are rent review mechanisms. So generally speaking, in retail legislation, the landlords need to specifically choose one rent review mechanism, such as a CPI review or a fixed percentage. There's not the opportunity to include the higher of CPI or say 4% increases. This ensures that there is certainty and it is clear what a tenant can expect each year when their rent is reviewed. Whereas with commercial leases, you find it's more often common to see, the higher of two options if that's what the market is calling for. Moving to market rent reviews, these are generally used at the commencement of an option term. Retail tenants are to receive the full benefit of a market rent review in the event that the market is calling for a decreased amount to the existing rent. Therefore, what we call a ratchet clause, which is when the rent can never be decreased, those types of clauses can be inserted into commercial leases, but it is specifically prohibited on a retail lease level. Some states also require landlords to give formal written notices to their tenants if the lease term is coming to an end and there's not an option term or an option period for the tenants to exercise. For example, in Queensland and New South Wales, landlords must give at least 6 months notice to their tenants if there is no option period. And in that notice, they need to specifically confirm whether the landlord does not intend to give the tenant a renewal or extension of its lease, or they need to set out their proposed offer to extend that lease instead. Please be mindful that there are strict timeframes when giving these notices that need to be followed that are subject to the Retail Acts. And therefore, if those strict timeframes are not followed, there may be consequences. For example, the tenant could rely on the position in the Act and ultimately receive the benefit of an automatic extension to their lease term up to 6 months, which can be really detrimental to a landlord if they already have another tenant lined up to move into that space at the end of the existing lease term. Moving to relocation and demolition timeframes, the Acts will set out specific notice periods for landlords to include in their leases to give to a tenant if they wish to relocate the tenant or relocating the tenant to another part of the building, or if they wish to completely end the lease to undertake, say, a demolition or major refurbishment works to their building. For relocations, it's generally a 3 months notice period, and for demolition, a 6 months notice period. And landlords usually have to assist with relocation costs. So that would include legal costs for the tenant to have their lawyer review the surrender deed of the existing lease and then review a new lease for that new premises that they're being relocated. There's also defitting the existing premises and moving that fit out and stock to the new premises. So all those moving costs and also the cost of refitting that new premises out for the tenants. For demolitions, landlords may also need to pay for reasonable compensation to a retail tenant for the displacement due to the demolition for its fit out value that they were no longer able to be using if they are having to vacate early due to that termination of the lease. So these are things to keep in mind if you are planning to refurb your buildings, and in particular for larger retail shopping centers, there is more space for you to move tenants around depending on your tenancy mix. So please keep in mind that there are compensation and requirements there for you to comply with. For commercial leases, relocation and demolition clauses are ultimately up to the parties to negotiate these terms. You might look to offer them specific timeframes that are in line with the retail legislation and offer some sort of compensation, but there is no specific compliance requirements for you to do so. Landlords may also be required to pay reasonable compensation to a retail tenant for their loss and damage if suffered in relation to disruptions of the tenant's trade, such as restricted access to the shop, changes to flow of customers in the retail shopping center. Ultimately, there are lots of scenarios where there could be breakdown of plant and equipment, such as air conditioning, which ends up you see claims being made by tenants for these disruptions because they're not able to use the premises as they should from the beginning of the lease. And also too, this does go further in that if you fail to prevent these disruptions, you might be liable for compensation as well. Landlords can try to limit their exposure to the compensation claim from a tenant with written confirmation of the full details of an anticipated disruption. So that is where in the disclosure statement, you would include those particulars and also in the lease documents. And each state legislation does have specific requirements for trying to limit that exposure, but it is something to keep in mind if you are wanting to undertake a refurbishment and going back to those relocation and demolition clauses as well, that you might be exposed to giving some sort of compensation to tenants if they do make a claim. Lastly, it is also best to keep in mind that in New South Wales, it is mandatory for a retail lease to be registered on title promptly after signing, and not all states require this. So it is important for lawyers to be across this and making sure that we are registering the leases afterwards, after they're all completed. So moving to security requirements, There is a common position for landlords to require a cash bond or a bank guarantee from a tenant under a lease. This security is in addition to a personal guarantee from an individual of the tenant company. There are pros and cons to each type of security. For cash bonds, a pro is that it is more accessible than a bank guarantee because it is within your possession during that lease term and you have it as cash. Whereas for a bank guarantee, it's not as accessible because while you are holding the original bank guarantee, you still have to take it to the bank to get the cash money from the bank so that you can use it and apply it to any debts or any amounts that the tenant is owing you. There is also a con for for a cash bond. And so in the event that the company that is your tenant goes insolvent or if an individual goes bankrupt, even though the cash is within your possession, it could be easier for a liquidator to recover the cash from you because it's technically still the tenant's money. Whereas with a bank guarantee, that money, that promise is being made from a third party, which is the bank, and they are saying that those funds are made available to you in your name. So that means that it's a separate entity that has made that promise and the money is with them. So it might be more difficult for a liquidator to recover that bank guarantee, specifically from those monies to call on for the liquidation, and therefore it might be more beneficial to you as a landlord that you could still call upon those monies if need be. So something to keep in mind when you are requiring tenants to pay cash bonds and bank guarantees. Moving to key maintenance and repair requirements and the differences between retail and commercial leases. Generally, leases will include structural, capital repairs, and replacement costs. For retail leases, though, generally landlords are prohibited from recovering these costs from tenants, whereas with commercial leases, it's ultimately what the parties decide to include and negotiate in their lease. And you can often see that tenants still may be required to pay for some replacement costs. You'd also likely want to include in your lease specific confirmation as to which party is responsible for air conditioning costs. So whether that's repairs, routine maintenance contracts as well. For both retail and commercial tenants, there's generally a responsibility that the tenants are responsible for these costs. And if they fail to do that, then they would also be responsible for replacement costs if they're a commercial tenant. Otherwise, if you don't specifically include these provisions in a lease, it's not very clear, and there are lots of disputes that we see for air conditioning costs, and it should really be spelled out specifically for repairs, replacement costs, capital repairs for air conditionings. And it's good to include the maintenance contracts, whether that's a routine intervals of, say, twice a year, every 6 months, that the tenant would need to undertake just to ensure that the air conditionings are operating correctly. Also, generally leases will have a redecoration requirement for repainting or recarpeting the premises. These are more common for retail tenants when there are higher standards for, the presentation of the shop because there's customers that are coming into the shop, once a term, depending on how many years of the term there is. However, it is also sometimes required for commercial tenants as well. Of course, that's depending on what type of building it is. Say, for instance, it's a warehouse, you probably are not needing to repaint or recarpet it, but it is important to make it clear as whether that is required at a specific time frame or whether that is required, say, at the end of the term and included in the make good obligations instead. Speaking of make good obligations, we will move on to that next. It is best to include a clear scope of what your make good obligations are so that the tenant is aware of what they need to return the premises to at the end of the term. There are a couple of options for this. One being that the tenants would need to return the premises to a condition as from their first date of occupation. Generally, this would include a fair wear and tear exclusion. And to know what this condition was at the first date of occupation, it is beneficial for both parties to undertake a condition report. And this should be undertaken just prior to handover of the premises from the landlord to the tenant. And this can include photographs of the premises, if there's anything in particular of concern. And it's great to just document specifically and have that document agreed between the parties that this is the condition that the premises needs to be returned to. And it's quite clear for the make good obligations at the end of the term. Another option is to require tenants to return the premises to a bare shell or base building condition, or if there's a specific layout that you may require. And then this would require the tenant to remove all of its fit out at the end of the term, whether it was installed by you, for instance, or them. And then they would need to leave the premises bare. And then it is ready for a new tenant to come in and, make the premises their own if they have a large fit out. You may also want to consider including an option for the tenant to make a payment to you in lieu of undertaking their make good obligations. If this is something that you're wanting to do, this would allow you to then receive the payment that you can either undertake the make good obligations or part of it, depending on who's coming in and what they're wanting. But basically, that payment that is being made to you is simply the compensation for what the tenant is responsible to have undertaken as agreed in the lease at the end of their lease term. Moving to incentives, you as landlords may be thinking about providing some sort of incentive to a tenant to induce them into leasing your premises. There are a few different incentive options you may want to consider. There are rent-free periods, and rent-free periods are generally used at the beginning of a fit out period. So whether that is an early handover opportunity for the tenant to get into the premises before that lease commencement date, or if they're commencing the lease and then having a couple months of rent free. Just so that the tenant has some time to fit out its shop and get ready to trade, whether that's stocking the shelves and whatnot, but it gives them some comfort that they are not having to pay that rent just yet as soon as the lease commences. With rent-free periods, generally those amounts are applied directly to the tenant's rental ledger, so there's not specific cash going between the parties. You may also consider giving a rental abatement. A rental abatement is a reduced amount to their full rent payments. So you might agree to give a specific amount of money for the tenant to the tenant that will be applied against their rental ledger for the entire term. And so that amount is reduced in equal amounts across the term for its monthly rent. And again, this reduction is applied directly to the tenant's ledger, so there's not specific money going back and forth between the parties. So there are two different options there, whether it's fully rent-free and then full rent becomes payable quite quickly after the commencement date, or if there is a reduced rent for the entire term, which is the rent abatement situation. There are also fit-out contributions that a landlord may be considering to give to a tenant to assist them with fitting out their premises. Generally, this is when there are, larger fit-out requirements, if builders are involved. That's where a fit-out contribution can be paid to a tenant or directly to the tenant's contractors from the landlord. For fit-out contributions, you may want to also consider if you wish to retain the ownership of the fit-out that you paid for at the end of the lease, and you may require it to be left at the premises instead of it being removed as part of the tenant's make good obligations at the end of the term. Or you may look at automatically passing ownership of the fit-out that you paid for to the tenant, and therefore they would be removing that fit out at the end of the lease term. Also with fit out contributions, something to keep in to keep in consideration when you are discussing the amount being given to a tenant. You may want to say that there are stages of that incentive being paid. So part of that incentive being paid at when they get handover, and then another part of it being paid when they have, a couple weeks into getting the fit out, and then the last, say, 20-30% being paid once they start trading, so that you're not fully exposed to paying the entire amount at the beginning of the transaction, so that just to make sure that the tenant is undertaking that fit out and it's going to be completed. You should also be aware of potential repayments of the incentives, though, because should a tenant not fulfill its lease obligations and the lease is subsequently terminated by you due to their default, you may want to seek repayment of that incentive or part of that incentive. But please be aware that depending on the situations, while the parties may agree to set a pro rata amount payable by the tenant back to you, so in that situation, sometimes as long as they fulfilled 2 out of 5 years, they only have to pay 60% of the incentive back to you. There are situations where it could be considered a clawback of the incentive, and where there are clawbacks, it could also be considered a penalty of law and ultimately unenforceable for you to try to get that money back. So please just be aware that there is no specific guarantee for repayment in these situations, and we can of course look at that further depending on the situation. So that concludes the main part of our webinar. You might find our publication useful. It is called Managing a Lease When Purchasing a Business. You can access it via scanning the QR code now or when you receive the slides after completion of the webinar. You may also be interested in our next webinar, and we would love for you to join us. The webinar is called Common Disputes in Retail and How to Avoid Them. It is next Thursday on the 19th of February at 11 a.m. again, and you can register your interest in the webinar at the link provided on the slide. We're going to answer your questions shortly, and while you submit them, I'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers who are all for your business as usual needs. Our team can assist you with unlimited document drafting and reviewing of commercial and retail leases and other business contracts, unlimited legal advice consultations, which means that you can book in as many consults with us you need to discuss your day-to-day leasing needs. And also we offer unlimited domestic trademark registrations and much more, with options to purchase extra credit towards lease negotiations, complex matters, and ongoing disputes, which are charged on an hourly rates basis. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all of the business as usual legal work, so you can focus on running your business yourself. And if you are an in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal tasks. To learn more about our membership or how our desk extension can help you, request a free consultation when the survey appears at the end of the at the end of this webinar. So while I'm answering your questions, you'll see a poll question pop up, and we'd appreciate it if you could please answer that. So we'll get started with answering some of your questions. Okay, so someone has written in how they charge for electricity if there's no separate meter. With that being said, generally what happens is each tenant would pay its proportionate share of electricity, and this would be calculated on a ratio of the lettable area of the building versus the area of the premises, and then you would get a percentage that would be payable. Next question we have is, do commercial tenants pay outgoings, and what are typical outgoings? So that's a really great question, and we briefly touched on it earlier. And so we'll go into a bit more detail now. Outgoings are the operating expenses incurred by a landlord to manage and maintain the property. With a majority of leases we see for both retail and commercial, tenants do pay their proportionate share of outgoings for their premises in relation to the entire building. But ultimately, it is up to how the parties want to negotiate the payments that are being paid. There is an opportunity that the rent becomes a gross rental amount, which includes the outgoings in there, and then outgoings are not specifically charged outside of it, which would be a net rental amount, where that is the net rent and then outgoings on top of it being paid as separate amounts. The scope of outgoings that are changes really dependent on whether they are a retail tenant, because most states do prohibit certain outgoings from being recovered by tenants, such as those capital costs and structural costs that I had mentioned earlier, also depreciation costs and sinking funds, and also land tax. Certain states have land tax not being payable by tenants. We'll move on to the next question, which reads, does a lessor's disclosure statement override the lease? So that's for retail leases. Ultimately, the lease is the binding contract between the parties, which means that it does take precedent. However, there are certain situations where potentially the disclosure statement is the term, what has been included in the disclosure statement is what is relied on. And that's where if outgoings were not outlined correctly in the disclosure statement, so it's really important that you do include a clear confirmation of those outgoings that you are wanting to pay. Sorry, or that you pay and wanting to recover from the tenants. And also too, if a disclosure statement is misleading or materially false, in those two situations, there could be an argument that part of the disclosure statement may override the lease. But it is, of course, dependent on each state, depending on what the legislation says. The next question, there's a bit of a combo that we can have here. There's two questions that are similar. And this is in relation to what happens if a tenant is breaching the lease obligations, in particular if they stop paying rent, and what's the procedure to get them out of the property, and how long does it take? So in this situation, generally speaking, if a tenant has not complied with an obligation under the lease, then the landlord can issue a notice to remedy breach, which is a written confirmation from the landlord to the tenant, which outlines the tenant's breach of the lease, specifically making reference to that clause and what that obligation is. So if that's for failure to pay rent on time, failure to comply with the make good obligations, or in the situations where a tenant may not have provided its bank guarantee, you just need to specifically state what has been their failure, and then also include a reasonable remedy date for the tenant to comply within. So in the event that the tenant fails to comply with the notice to remedy and remedying that breach within that reasonable date, then the landlord may be able to take action to retake possession of the premises, whereby the lease is then terminated. Some states, such as New South Wales, has an exemption for non-payment of rent. So you may not have to provide that written notice of that notice to remedy breach first before retaking possession of the property. But please always be referring to the lease terms and the state's property legislation to understand the position. This can be a really technical area, and I always recommend that clients please, before issuing a notice to remedy breach or taking action to remove a tenant from a premises, that they speak to someone in our leasing team or in our disputes team. We can definitely help you out. It is a complex area of law, and we want to make sure that your rights are protected as landlords and you are doing it lawfully, and to reduce any chance of a tenant making a claim against you if you end up retaking possession. There's another great question that's speaking to items that we should be that you should be aware of when entering into a new lease, or also examples of what may be commonly disputed in leases. So there's two key lease clauses that generally create disputes, unfortunately, that we do see commonly. The first being make good obligations. The reason behind this is because make good obligations can become quite onerous quite quickly, depending on the condition of the premises and what a tenant has installed as part of its fit out versus what had been there at the beginning of the lease. Sometimes leases will just say that you do need to remove everything, and while that is more clear, or it can be quite clear that you just need to bring it back to that bare shell. Sometimes you can see that these costs weren't necessarily understood potentially from the tenant when they were signing the lease, and it ends up being quite a lengthy process to remove everything from the premises and bring it back to a bare shell. And it does take quite a bit of time. So what you might see is that tenants will have to, shut down their business earlier so that they do have enough time to do the make good obligations. And in that situation, sometimes you see tenants requesting to extend their lease a little bit so that they can fully comply with those make good obligations. But it's really important that it's quite clear as to what's required there. Another one that we see disputed quite frequently are air conditioning maintenances or other services, generally more structural services, such as if there was a lift in the premises, for instance. But air conditioning maintenance, especially with our weather here, it can be, it's really important that the lease specifically states who is responsible for the repairs, who is responsible for the replacement costs, capital repairs. All of that's really important, because the breakdown of plant and equipment can sometimes become the landlord's responsibility, or it might be the tenant's responsibility, in particular for commercial leases. For retail leases, it's generally, more protected under the acts that spell out the limitation of capital and replacement costs being paid by the tenant. So it will generally end up being the landlord's responsibility. But these situations, when there are breakdowns of plant and equipment, it can become quite costly. And especially if you are relying on that air conditioning to be used for, your staff or customers, it can be quite difficult if it's giving you troubles of making sure that you're able to have a comfortable area for your staff without complaints. So it can be quite costly to get those fixed. So we've got another question that from a landlord's point of view, which lease clauses tend to cause the most friction later, even when the lease was well drafted? That's a great question, and that's perfect timing with these ones as well. Those are make good obligations and air conditioning maintenance or other plant and equipment. Those are generally the ones that, they could be maybe overlooked by the other party who is, drafting or reviewing the document. And from a tenant responsibility, they might have thought that they shouldn't have to be paying for that, whereas the lease might say that they do have to pay for that. So those are the ones where the cost can just add up quite quickly, and that's where, yeah, you see some friction. There's a question about preparing lease documents and the terms in it. That question, I think, is we can certainly assist with preparing documents, and we can speak further about this on a consultation. But yeah, we certainly draft documents. What happens if a tenant surrenders the lease? So a tenant would likely have to breach the landlord first in order to take action to surrender the lease. That's dependent on what the lease terms say and also the property laws for that specific state. And then if that were to occur, the landlord would then need to be searching for a new tenant to take up the premises. So what happens when, so one of the questions is when the tenants present the landlord with a new purchaser to take over the lease without any heads up that they're wanting to sell the business. So this relates to an assignment of lease, and it generally, as part of a business sale, the existing tenant would need to get the landlord's consent to have the incoming tenant take over that lease. And so you've also requested if you can cover the reasonableness of the landlord's requirements and expected timeframes. So yes, this is a really great question, as we do often see this with business sales. Unfortunately, sometimes this ends up being a bit rushed with tenants and incoming tenants. Those buyers of the businesses and the premises may leave this to, more of the last minute of the transaction. And unfortunately, it does take some time. And so it's important to, understand that it does take some time. Just flagging that this question is a bit more complex, and there are a few factors to play here, but really at a high level, it is dependent on what the lease terms specifically say that is required as part of the assignment of lease process. There are property laws of each state, and for retail leases, the Act will generally set out what is required as part of an assignment and whether there are limitations for the landlord's consent, which cannot be unreasonably withheld or delayed. Ultimately, it's best if all the parties are working together, and that if you do, as landlords, if you do get more time to more of a heads up from tenants, and so that doesn't leave you in, a bit of a stressful situation and having to, having ultimately, if settlement needs to get delayed. Something to consider, generally speaking, the common requested documents for a landlord's consent is getting business references, assets and liabilities statements from the company and their directors, which might be guarantors of the lease. Generally speaking, too, with retail assignments of leases, there are disclosure obligations between the existing tenant and the incoming tenant, and potentially with you as a landlord being involved as well. So it's important that, that everyone's across the Act and what is ultimately required. Otherwise, what is specifically reasonable is really dependent on the situation. So that's depending on the type of lease, what the rent is, the payable amount is, because you want to ensure that the incoming tenant is financially in a position that can comply with their obligations under the lease. Also, to the term of the lease and the type of tenant who's already in there versus who is coming in, because if you are getting a tenant that is not as well known, there could be, concerns there. And also to specifically for retail leases, sometimes there are limitations that you can withhold your consent if the permitted use changes, and that just goes back to the keeping, shopping centers having a good tenancy mix. So yeah, things to think about. There is also for retail leases, some states have a 28-day time limit for landlords to confirm or reject the incoming tenant as part of the consent process. So it is important that you do think of that time frame. That's in New South Wales and Victoria, and it might also other states. It's just dependent on making sure that you're across the legislation to know if you do have that time frame. And that's specifically confirming whether you accept or you reject and you have a specific requirements from the tenant to give you additional information. And that time period generally kicks in once the disclosure documents are specifically provided and all compliant. We have reached our time limit for today, and I have not been able to get to all the questions. So please send through on the feedback webinar or the feedback on the webinar if you have specific questions, and we can definitely reach out to you. Sorry that I haven't gotten to them all today, but it was lots of great questions, and thank you for your time. Please also submit your details in the survey for those questions that we didn't get to, or also if you want to learn more about how our membership can help you. While this is a free webinar, we do value and appreciate your feedback. So please complete the 30-second survey at the end. It's great to get your feedback so that we can keep improving and creating more webinars in the future. Thank you again for all your time for joining me today, and I hope you have a great rest of your day. Thank you. Bye.